of the L2 construction series. I'm Loon, together with me, my host partner, Leong Hoong. Good morning, everyone. Today's topic is an overview of Singapore's COVID-19 Temporary Measures Act. This is how Singapore is dealing with the COVID-19 situation there. And we have three speakers today, all of them from Withers KhattarWong, is a law firm in Singapore. The first speaker is Tan Spring. You know, when I look at this name, at first I thought that Spring was her English name, but I was told that this is her first name and Tan is her family name. So Tan Spring. So she will be our first speaker today, followed by Lam Zhen Yu, her colleague, and Chua Hoong. After their presentations, then we will proceed with the questions and answers session, and we will also be taking questions from the floor. Now, we hope that all of you will gain some insights, especially Malaysians, as to how Singapore deals with their situation and how effective it is and what are the legal implications arising therefrom. Now, without further ado, I will pass the mic to Tan Spring for her to firstly introduce a little bit more about herself and proceed with her presentation today. Over to you, Tan Spring.
Thank you, Loon. Good morning, ladies and gentlemen. My name is Spring. I'm from Withers KhattarWong, and I'm a partner in the dispute resolution team, handling commercial litigation, international arbitration, adjudication, mediation with a special focus on construction and engineering matters. With me here today are my partners. Is my partner Hoong, Chua Hoong. She's a partner in the private client and tax team, and our associate Zhen Yu, who is also in dispute resolution, specializing in insolvency. Next slide, please. Okay. We're here to share with you an overview of this new act that has been passed in Singapore. That was on 7th of April. It's called the COVID-19 Temporary Measures Act. There are several parts to this act. The key parts will only come into operation sometime probably later part of this month. The other parts are already in operation. This act is intended to cease effect after 1 year. The objectives of this act is, well, as all of you know, the sudden and widespread outbreak of the coronavirus not only has caused grave concerns over public health worldwide, but it has also significantly impacted businesses and affected the ability of many businesses and individuals to perform their contractual obligations. Most countries are by now in some kind of lockdown. In Malaysia, you have your MCO. In Singapore, we have our CB, which is circuit breaker measurements. So this act is intended to provide some fairness to people who are caught up by the COVID-19 outbreak. So it's targeted protection from legal action, and it gives businesses and individuals cash flow relief for the impacted sectors. It is meant to be a temporary relief, holding the right to exercise contractual obligations while recognizing the unprecedented effects of COVID-19. So that means you do not absolve or remove any contractual obligations, but you suspend them for a prescribed period of time. For now, it is 6 months, which may also be extended if necessary. Next slide, please. Okay, the areas that are covered by the Act, there are many parts. Part 2 covers temporary relief for inability to perform contracts. I will be providing an overview on this. Part 3 covers temporary relief for financially distressed individuals, firms, and other businesses. This will be covered by my colleague Zhen Yu. Part 4 is temporary measures for conduct of meetings. This relate to companies, secretarial matters like AGMs and all that. We will not be touching on this today. Next slide, please. Part 5 is the temporary measures for court proceedings and Shara court proceedings, which we'll not be touching on either. Part 6 is the temporary measures concerning remission to property tax, remission of property tax. This will be covered by Hoong. Part 7 is COVID-19 control orders, which is already in operation. There are, next slide please. There are actually 5 broad categories of contracts covered. The first one, construction contract or supply contracts. And then there are secured loan facilities and the similar facilities. Zheng Yi will be providing the details. The next category are leases for non-residential properties. This will be covered by Hoong. And then there are event contracts, which we will not be touching on, and tourism-related contracts, which we are also not touching on. Now, these contracts that are covered, it excludes contracts entered into on or after 25th of March. So if you now, at today, 17th April, enter into the contract, it will not be covered by this act. And it covers obligations to be performed on or after 1st February 2020. And it includes contracts which the government is a party to. That's good news for a lot of people. Now, how will the relief work? Relief will be available where a party is unable to perform an obligation due to be performed on or after 1st of February. And that inability is materially caused by COVID-19 event. And then a notification for relief has been served on the other party. Next slide, please. Upon receiving this notification for relief, the recipient is not allowed to take the following types of actions. Number 1, he cannot call on the performance bond given pursuant to a construction contract. No court actions are allowed. No insolvency proceedings. This will be covered by Zheng Yi. No enforcement of securities. And then there's no termination of lease of non-residential premises allowed. This will be covered by Hoong. So in theory, for example, if you supply construction contracts and sometime in November last year, you were awarded a contract by a main contractor to carry out interior decoration works at, say, Changi Airport. Now the project period is for 12 months with monthly progress payment with a 30-day payment terms. Now you started work in December 2019, last year, and then you issue a claim towards the end of December. Payment would then be due 30 days and January. As usual, as in most construction contracts, there is a delay in payment. However, you continue your work for the next 2 months, January and February, and then you issue your second and third invoice towards the end of January and February, with payment due on February and March. At this point in early March, things were already getting very bad. There's a big slowdown. I mean, I'm talking about the situation in Singapore. There's a big slowdown. Jobs have been cancelled here and there, and there are no new projects for contractors like interior decorators, you know. So you have not received your payment for your first invoice. You decided to stop work. Why should I work for free, right? And the main contractor, whose project is already in delay, insisted that you continue or else. Okay, now then come April, early April, the circuit breaker measures were announced and kicked in very quickly. So all construction works in Singapore had to be stopped except for some exceptions, essential services, you know, safety reasons. So you can't really do anything anymore. Now, what can you do about the main contractor's payment obligations to you? The first invoice which you issued end December would have been due end January. So this falls outside of this act because it's supposed to be from 1st Feb to onwards, okay? So it's not applicable. The relief is not available to the main contractor, and the main contractor has to pay. Now, for the second and third invoices, they are due on or after February 2020. That means the main contractor can claim relief from payment if, that's a big if they can show that their inability to pay is materially caused by a COVID-19 event, and a notification for relief has been served on you. So that's what they need to do to rely on the Act. Now, as for your obligations to carry out the works, the interior contracting works, generally, you in most construction contract, you can only stop work when there's non-payment if it's provided for in your contract. And this is normally not the case. I mean, the rationale for this is that so that a construction project involves many different trades. And if one trade decides to stop just because they are not receiving payment, it will jeopardize the whole project. That's why it's very important that there's no such kind of clause in the contract. And contractors are normally expected to continue working even though they haven't been paid. Of course, there are some extreme cases where, say, you haven't been paid for a very long time or for a very big sum. You can then try to rely on certain common law act, common law. Now, there are of course also recourses like applying for adjudication. In Singapore, it's the SOP Act, and I think for Malaysia, it will be the CIPA. Now, in addition to all that, your contractual obligation to carry out work, if it falls on or after February, relief is available to you if you can show that to carry out your inability to carry out the works is materially caused by a COVID-19 event. And a notification for relief has been served on the other party. How that will play out in real life, we don't know yet, but that's the intention of the Act. I have already been advising a few clients who are in this kind of situation. So what's important now is to make sure that notification for relief is given. So whether or not it will stand and whether the Act will actually provide relief and what kind of relief, bearing in mind this is supposed to be suspensory, meaning it suspends your obligation. It doesn't waive your obligation. Now, assuming there's a dispute as to, I mean, the party that you serve the dispute, the notification for relief on, doesn't agree with you, what can they do? Next slide, please. So, parties may dispute the non-performance of contractual obligation was due to COVID-19. Disputes then will be determined by an assessor from a pool of assessors appointed by the Minister of Law, and the assessor will decide if the non-performance was due to a COVID-19 event, and the assessor will have powers to grant relief to achieve a just and equitable outcome. There is no appeal allowed from a determination made by the assessor. Doesn't this sound something like your CIPA and our SOP? I think this is just their quick way to try to resolve disputes for the time being. So let's see how all these pan out, and we will share with you in future if there's an opportunity. I have finished my presentation and I will pass the screen now to my colleague Zheng Yu. Thank you.
Okay, thank you. Excuse me. Thank you, Spring. Good morning, everyone. I am Zhen Yu, and I specialize in restructuring and insolvency in my firm. I actually sit in the dispute resolution team, but we deal a lot with cases where companies are insolvent. And actually, as part of the new law that Spring has kindly introduced to everyone earlier, the Singapore government has also put into place certain protective measures, changing the insolvency laws of Singapore. Now, the government of Singapore has recognized that the current COVID situation might pose a serious threat to to many businesses. Many businesses in this period will likely go insolvent, at least for a certain period of time. And it's very likely that if the usual insolvency laws apply across the board for everyone, a lot of businesses will be wound up in this 6 months to 1 year period during which the economy is really badly hit by the COVID outbreak. For example, for construction companies, it's very possible that many construction companies, both in Singapore and Malaysia, have stopped work in this time period. And so therefore, you might be racking up damages, you might be incurring costs for paying your employees, even though you have stopped work for the time being, your overheads are still being paid. So the Singapore government is trying to protect vulnerable businesses in the economy from being hit and from going under in this period. So today I'll just be sharing with everyone the experience in Singapore with the implementation of these new measures in respect of insolvency. Next slide, please. So I've set out in this table a very simple summary, a very general overview of actually what are the changes that apply across the board. So just earlier, my colleague Spring has mentioned that there are certain kinds of contracts that are protected under the Act. One of the kinds of contracts that are protected under the Act, which of course all of us here will be very interested in, are construction contracts. But these changes in this table here actually apply across the board, regardless of whether your claim is pursuant to a protected contract or we call a scheduled contract in this Act. All insolvency actions in Singapore in what we call the prescribed period of at least 6 months to 1 year will have to abide by this new insolvency changes. So whether you are, for example, just making a claim on an ordinary contract, a services contract, that is outside of the construction regime. Or for example, even if it's an unsecured bank loan, your bank will have to comply with this new restrictions imposed under the COVID Act. So let me just bring us through some of these changes. Now, I believe the system in Malaysia is very similar in Singapore, where if you want to wind up a company or you want to make an individual bankrupt, you usually first issue what we call a statutory demand for payment. Now, this statutory demand for payment is actually for the purposes of proving that this company or this person is unable to pay their debts. And so on that basis, after the period of time expires, you go to court and you apply for what we call a winding up petition or bankruptcy petition. Now, in the usual course of business, and I believe it's similar in Malaysia, in the usual course of business, the law actually provides for statutory demands for payment to be satisfied within 21 days or 3 weeks. Is the same thing. So the new Act actually changes this to 6 months. So what this means is usually in our experience, when we want to wind up a company, we'll issue a statutory demand, wait 21 days. On the 22nd day, we will go to court and we'll file a winding up application against the defendant. And usually the court will fix a hearing for us within about, say, another 3 to 4 weeks. So within 7 to 8 weeks, in less than 2 months, I can have a company wound up just by issuing a statutory demand and following through with the process. Now, the initial 3 weeks period has been extended to 6 months, which means companies have a lot more breathing room. Can you imagine if in this period, when your business is closed, when you're not having revenue coming into your company and you're served with a statutory demand, in 3 weeks, you will not have the time to raise enough funds to pay the creditor what he or she is due. And so therefore, this 6 month period is meant to give breathing room for companies to raise funds to pay their statutory demands. Now we move on to the rest. The threshold for making a company wound up or for making a person bankrupt have also been raised. In the case of a company, the threshold has now been raised from 10,000 to 100,000. It's a 10-fold increase for this prescribed period. And for personal bankruptcy, it's a 4-fold increase from 15,000 to 60,000. Now in Singapore, we also have what we call a debt repayment scheme, which is when a person is unable to pay his debts, but he does not want to be bankrupt. He can actually go to court and have what we call a debt repayment scheme approved. And previously, as long as you have more than $100,000 worth of debts, you will not be able to apply for this debt repayment scheme. But now this threshold has been raised 2.5 times to 250,000. And so therefore, you can actually have the official assignee, which is actually a government agency under the Singapore Ministry of Law, helping you to manage your affairs and to pay your debts for a period of 6 years, as long as you owe no more than a total of 250,000 Singapore dollars. Now that really gives people a lot more options, a lot more space, so that they can manage their financial affairs without the threat of winding up and bankruptcy hanging over their heads. Another very interesting new measure that the Singapore government has applied to an insolvency regime. And this is very interesting because typically in the normal course of business, companies that incur debts that they are not able to pay while they are insolvent, or persons who incur debts that they have no reasonable expectation to pay. If the company gets wound up or if the person gets bankrupt, the officers of the company and the bankrupt will have committed an offense, which might make them liable to be prosecuted. Now, for this prescribed period, the government has actually lifted this, which means that actually, in reality, in this prescribed period that the government has set of at least 6 months up to 1 year, it is possible for people to still run their businesses even though they are insolvent and they are not under threat of criminal sanctions. Now, of course, there's the provision that they must be incurred in the ordinary course of trade or business. So, for example, if your company deals in construction, you cannot be incurring debts in an area that is completely not related to construction, and you still commit an offense. But if you are trading in the normal construction course of affairs and you incur debts even while insolvent, you will not have committed an offense. Next. So earlier I've mentioned some of the changes that apply across the board for all kinds of contracts for the insolvency regime. Now I'll focus a bit more on the areas which my colleague Spring mentioned earlier, of some kinds of specialized contracts that are specially protected under this new COVID regime. And so just now Spring discussed construction contracts. Another kind of contracts which are protected are actually secured loan facilities. So over here, you qualify, your loan facility will actually qualify to be protected if the lender is a bank or finance company that's registered in Singapore, and if you, as a borrower, you are an enterprise, or what we call SME, small to medium-sized enterprise in Singapore. There are certain conditions on what it means to be an enterprise. One is the ownership requirement. The company must be owned by at least 30% Singapore citizens or Singapore permanent residents. And the second is a requirement on size. Your annual turnover as a group must be no more than 100 million Singapore dollars. And as long as you qualify for these two conditions, lender and borrower conditions, you might fall under the protection. Next, the loan facility must be secured over this kind of assets, secure over land for commercial or industrial purposes. So for example, if your company has given security to a bank, for example, a mortgage over the director's home, well, that will not be considered a kind of protected contract under this regime. And also, if security is given in the form of plant, machinery, or fixed asset, which is used for manufacturing, production, or other business purposes. So, for example, if you have given the bank a charge over the equipment in your factory. Now, I know some construction equipment can be quite costly and can be worth quite a fair bit, and so it's worth giving security for. Now, good news for construction companies who have given such security is that their loan facilities are protected. So if your loan facility falls under a category of secured protected loan facility, you qualify for the same protections that Spring mentioned earlier. Of course, the same conditions have to be fulfilled. You must serve a notification for relief. The obligation must have been due to be performed after 1st February, and the contract cannot be entered into after 25th March. But as long as you fulfill all these conditions, you are protected. Now, next slide. So Spring earlier mentioned that for protected contracts, and this is including construction contracts. For protected contracts, no court actions can be taken. So specifically, as long as your contract is a protected contract, no winding up no bankruptcy and no judicial management proceedings can be taken in Singapore. Well, these are all court proceedings. So they actually fall under the blanket, protection against court action. Now, the good news over here under the new laws is that this also protects personal guarantors. And so personal guarantors who are given guarantees, directors who are given guarantees for their companies actually are protected from being sued and being made bankrupt in this period, as long as you are a protected contract. And also, some people might get creative and say, oh, look, all court actions are prohibited, but I can actually, for example, appoint receivers and managers under my security documents, and this is not court action. Well, so the new law actually imposes a prohibition against the appointment of receivers. Now, there's still some things that the banks can do. For example, if they have security, if the bank has security over bank accounts, sometimes banks will require security in the form of charges over fixed deposit accounts. Well, the bank can still set off the amounts in the FD against the amounts that's owed to the bank. So that's not prohibited, and they are free to do that, what we call self-help remedies. So next. So thank you, everyone. I'm at the end of my presentation. I'll pass over to Ms. Chua Hoong, who will touch a bit more on Singapore property tax measures.
Thanks, Zhen. Hi, everyone. My name is Hoong. I'm a partner in the Tax and Private Client Department of Withers KhattarWong. And my practice areas involves advising individual and companies on Singapore taxes, whether it's income tax, GST, stamp duty, property tax, and also advising families on their personal succession and tax planning. As we heard just now from my colleagues, there were a number of measures introduced under the COVID-19 Temporary Measures Act. And the aspect that was introduced that affects landlord and tenant, there were a couple. One of which involves the temporary relief that is granted for tenants who are unable to pay rent to landlord. This concerns property that are non-residential property, for example, your shops, your warehouses. The inability to pay rent is in effect deferred, but it must be due to the material extent, it must to a material extent be due to the COVID-19 pandemic. And that's one aspect of it under the Act. The other aspect is the aspect that I want to talk about today, which is the remission of property tax and how that affects the relationship between landlord and tenants. So perhaps I could do a brief introduction of what property tax is in Singapore. If I could go to the next slide, please. Singapore property tax is in effect a tax on property ownership. It is payable by the owner and it's payable regardless of whether the property is occupied, rented out, or vacant. And the tax is actually based on the annual value of property. Annual value is broadly defined to mean the annual lettable value of the property, regardless of whether the property is actually rented out. And the way you calculate property tax is by multiplying the annual value with the relevant tax rate to arrive at the property tax. So for example, the tax rate of a non-vacant commercial and residential building or land is 10%. So this constitutes a cost to every property owner in Singapore. And depending on the kind of property that you hold, this property tax will be payable according to the rates applicable to that property. Now, in Singapore, we had our first COVID-19 case on 23rd of January. Our annual budget is usually announced in February. And if I could go to our next slide, in our first annual budget announcement in February, actually we only have one annual budget every year, but this year is exceptional. So when the budget was first announced on 18th of February, the government announced that in order to also tackle and relieve some of the burden on business owners who have put their property to use, property tax remission meaning a rebate or relief, for the entire year 2020 for commercial properties will be granted. And initially it was given a 15 to 30% remission for categories like hotels, your convention centers, workers' dorm and tourist attractions, and 10% remission to the integrated resorts. Shortly following that, we had our property tax commercial properties remission order to bring that into operation. However, as the situation escalated in Singapore and everywhere else in the world due to COVID-19, the government then announced a supplementary budget. If we can go to the next slide, please. The supplementary budget is called resilience budget. Notice how they like to name the budget each time they announce something new. And on 26th of March, which is just over a month shortly after the budget was announced, they've decided that given the dire situation, 100% remission, that means no property tax is payable in year 2020 for these qualifying commercial properties. It's very extensive, but if you look at the categories, these are probably the industries that is the hardest hit due to the COVID-19 pandemic. Hotels, convention centers, the airport, cruise terminal, shops and restaurants, tourist attractions, sports building, dorms, schools, hostels, 60% remission for the integrated resorts, and 30% remission for all other non-residential properties. Okay, so it's only applicable to non-residential properties. Currently, this property tax remission has not yet been legislated, but the Inland Revenue Authority of Singapore's own practice guidelines has already announced and is in practice accepting that this is going to happen. So we're just waiting for the subsidiary legislation to put this into effect. Now, at the time when these two budgets were first announced, and that the property tax remission was announced in favor of landlords, if you will recall, property tax is payable by the landlord. But what about the people who have to rent from the landlord in order to run their business? They do not benefit from this. So initially, when the government first announced the property tax remission, they said that, oh, landlords are highly encouraged to pass on the benefit to tenants. However, a highly encouraged means it's not enforceable. So due to a lot of sentiments from the ground, the government then decided to legislate the obligation of the landlord to pass on the remission of the property tax benefits to the tenant. And if we can go to the third slide, this is the next slide, please. This is actually encapsulated in the COVID-19 Temporary Measures Act, right, which was passed in Parliament on 7 April. Now, the transfer of the benefit of the property tax must be passed from the owner, property owner, to the lessee or the licensee. Now, when the landlord does that, it cannot subject the passing of the benefit to a condition, right? And if they do subject it to a condition, any renegotiations, for example, over the lease terms imposed for the passing on of the benefit will be deemed void. And the corresponding amount of reduction in the property tax may either be paid to the tenant as a lump sum or by way of installments, or be set off against the rent payable by the tenant to the landlord. And another thing that is also legislated by the Act is if there is a dispute between landlord and tenant over how this benefit is actually passed from the landlord to the tenant, there is a valuation review panel that will determine the disputes. So we're looking at a dispute mechanism that's also provided for under the Act. Now, currently the primary Act is already there. Operative date has yet to be announced, and there will be subsidiary legislation that will be gazetted to further outline the details as to the timing within which the property tax benefit must pass from the landlord to the tenant. As I mentioned just now, the property tax is an annual tax to be paid by the property owner. It probably has already been paid since a lot of property tax bills are issued in January. However, there could be other adjustments along the way due to the valuation of the property, which then affects the annual value and therefore ultimately affects the property tax payable. So we'll have to see what the details of the subsidiary legislation says in terms of how the landlord must pass that benefit to the lessee or the tenant. And that is the end of my presentation today.
Thank you, all three speakers, for the informative presentations. This is definitely something new to me, and I have lots of questions now. I will start with Spring. Spring, are you there?
Yes.
Yeah, Spring, under the Act, does this mean that all my contractual obligations are relaxed or waived for 6 months?
Unfortunately not. So you see, what they are trying to do is to provide temporary relief. Temporary. That means all your contractual obligations are only suspended. It doesn't mean that it's gone. In fact, our Monetary Authority of Singapore has provided some comments on this act, and then warn people that whatever contractual terms there are in your contracts with whichever party, especially like the banks, it will still apply. So for banks, they will definitely have late payment charges. They will have penalty clauses and interest rates. There will be that. It's all there. So if you can't pay and you are not paying, all these will apply. The only thing the bank can't do is like what Zheng Yu has earlier on mentioned. They cannot take enforcement action. They cannot commence court proceedings. But everything else in the contract remains. So it's not waived. Just bear in mind, it is just suspended. So the danger will be that you may be fine now. You buy yourself some time to actually make your cash flow more fluid. But if at the end of 6 months you are still not able to pay or unable to improve your financial position, then you're in a worse position, because all the interest rates will have mounted and all the penalties will be imposed on you, and then you might end up with a worse position. Thank you.
Oh, okay, Spring. Spring, also, as you told us, when the parties cannot come into agreement whether the non-performance is due to COVID-19 crisis or not, then an independent assessor will be appointed to resolve the dispute. I can see that the relief also provides for a binding dispute resolution mechanism to ensure that contracting parties are not abusing the system. But who pays for the assessor fee? Is it free?
Actually, all these are not known yet. I expect it to be actually run by the court system. So I expect it to be minimal if have to pay. So I think it's either free or it should be minimal, not like a normal court proceedings.
Okay, thank you. Also, we all know that there are these giant companies like Amazon, Google, or Facebook, just for example, which obviously have a deep pocket and are able to channel funds from their headquarters. So, which means their financial standing in Singapore may not necessarily reflect their actual financial standing. So my question is this: can a company as such rely on Act for relief from performing their contractual obligations?
Okay, unlike the securities facilities, that part, those companies, for those companies, the enterprise must be 10 million or less. Okay, for the rest of the act, there's no express definition. So companies like Amazon, Google, Facebook, all the big ones, if they can show that their inability to pay is materially due to COVID-19 events, then, and they have given a notification for relief, then I would argue that it's applicable for them to, although it sounds very unfair, I understand. But if they can show all that, of course, if they have a deep pocket and they try to say that, oh, they are unable to pay because of COVID-19, then that's a bit harder to prove.
Okay.
Thank you.
Okay. My questions now, I have two questions to Zhen Yu. Zhen Yu, are you there?
Yes, I'm here.
Zhen Yu. So if I have a claim for outstanding certified payment against a company under a consortium contract,
Okay.
does it mean that I have completely no recourse in the prescribed period?
Okay, so your recourse would be quite limited, but from my experience as an insolvency lawyer, what I'll actually recommend would be to still issue a statutory demand. Now, the issuance of statutory demand is actually not prohibited, and while, as I mentioned earlier, the statutory demand will be for 6 months for the defendant to actually pay up. There's still value in doing so, because after the prescribed period, immediately once the prescribed period is lifted, and assuming that 6 months have expired, you can straight away go and apply for winding up. Not that you actually want to do it, but it does place some pressure on the defendant to ensure that in these 6 months, they take the time to raise the funds to pay you back, and not to take the 6 months to dilly-dally and do what they like and only deal with it after 6 months. So there is some value as a creditor in still issuing a statutory demand.
Right. Okay. Thank you. Jenny, I was following your presentation earlier.
Yeah.
So does that mean that an enterprise does not have to, does not have to pay the bank lenders for 6 months, even if the loan is secure against machinery?
Okay, so I think I'll link back to what Spring mentioned earlier during her response to your question. I think the Monetary Authority of Singapore has made it clear that things like default interest, late payment charges, and all that will still continue to run. So it's not a situation where you can say, oh, okay, my installment payments I'll only start paying 6 months later. That would not be good, because the bank can still do things like recall your loan and cause the entire sum to be immediately payable. So actually, what the Monetary Authority of Singapore's recommendations are for borrowers to actually start talking to their bank lenders to arrange for, okay, perhaps if you can't pay so much installments per month, you pay less, but there's some kind of schedule that's agreed to, and so therefore the bank cannot call a default, because once they call a default interest, the whole amount becomes due, and it affects your ability to pay after the 6 months are over, and it'll make you more likely to be insolvent after the 6 months are over.
Okay, thank you, Jenny. Clear answer. That's all from me. I'll pass the mic to Wai Loon now. Over to you, Wai Loon.
Oh, thanks, Hoong. Thanks to Spring, Zhen Yu, and also Yi Hong. I have some questions for Yi Hong though. Yi Hong, relating specifically to your presentation, you mentioned about the property tax relief measures and the various measures implemented arising from this COVID-19 situation. What does this measure mean to the landlord or the tenant? Yeah.
So obviously the landlord is now getting a discount on the property tax, but it is required under the Act to pass on the benefit to the tenant. But the Act also says they cannot, in passing on the benefit, impose a condition on the benefit. From the landlord's interest perspective, the way I look at it is, first of all, they have a benefit to pass on, but the quantum of the property tax could, in the course of the year, be adjusted due to a revaluation of the property. And the way I look at it also, due to the expected economic downturn, a revaluation of property may not be unexpected. So if, for example, the property tax should be readjusted downwards in the future years, for example, how will this impact on the landlord's ability to claw back the benefit that has been passed on to the tenant already pursuant to this Act? We will have to see what the subsidiary legislation say and how this can actually be or how lawyers could actually advise a landlord when passing on this benefit, while also protecting the ability to claim back the reduced quantum of the benefit that has been granted to the landlord themselves. From the tenant's perspective, of course, they will say that they are entitled, and they will try to say that. But more importantly, I'm looking at the case of a subtenant. So for example, a building landlord could have rented property to a lessee who then subleases it to a tenant. For example, WeWork or these co-working spaces, that's the lessee. And the lessee then subleases it to, let's say, the small business owners or the startup owners who then rent and use these spaces. But they are the end user of the property, and if they are treated as subtenants, currently the Primary Act doesn't provide the definition yet of what constitutes a prescribed lessee or prescribed licensee. So again, we hope the regulations will actually provide some clarification as to who will be the person who will ultimately get the benefit of the remitted property tax. Thank you.
Thanks, Leong. Now, I'm going to put questions from the floor to the our special guest today. Spring, in particular, I have a question from the floor. They are asking about the assessors appointed by the Minister of Law to adjudicate disputes arising from the notification of reliefs. First of all, who are these assessors? Are they appointed from amongst the judges or from the private sectors?
Loon, sorry, actually, we don't know all this yet. That's what it says in the Act, that it will be appointed by the Minister of Law. But we suspect that it might probably be registrars or same group of people that do adjudication, because this will probably be construction related. But for the non-construction related one, I think any registrar in our court will be able to handle those.
I see. Under the current framework that you are aware of as of now, are these decisions from the assessors appealable? Is there any avenue of appeal?
Currently, what it says in the Act is that it's non-appealable. So, I mean, just like adjudication, I presume that for now, as long as this Act is in place, it's non-appealable. But subsequently, when there's no more restriction to court actions, you can always commence court action and reclaim back or reset back whatever you're unhappy with, just like in CIPA and SOP. I
see. So these decisions are only interim in nature. It's like a stopgap measure to deal with the emergency situations.
That's the way I read it, because this Act is meant to last only for 1 year. And because of the restriction in commencing court actions, people can't do anything. So whoever rely on this to seek relief should be able to have their disputes resolved this way. But that could be just temporary, right, in a sense. Because after that, all these will be gone, and then we are back to square one, depending on what the contract says for each party.
I see. All right. So we are actually yet to know whether this stopgap measure would be able to reduce disputes in the future, or it would actually just like a temporary relief, but eventually all these cases will surface back into the court proceedings or arbitration or adjudication later. Well, we hope to see that the environment will change for the better and not the other way around. And I would like to thank the three speakers from Singapore today, for their time, for taking the time to share their experiences in Singapore, which would actually provide, some insights to our people in Malaysia. And there's some, I can also see a lot of good suggestions. Hopefully that our government would also implement some of them in our jurisdiction as well. Now, before we end the session, any one of you has any concluding remarks for our audience today? Anyone who has any concluding remarks to make?
I think for the COVID-19 Temporary Measures Act, it was just passed in Parliament in 1 day on 7th April. So that was 10 days ago. And since then, the regulations has been amended 3 times in just 10 days. So we do see that because the legislation is fairly new, we do see that and expect that probably regulations will be further enhanced or tweaked in order to adjust and address the issues that could arise as we are implementing the new laws.
Thank you, Spring, Zhen Yu, and Yi Hong for coming to Malaysia from Singapore to spend time with us this morning. It's amazing, right? The world has been made so much smaller by technology.
Yes.
So yeah, as we can see, in a nutshell, the Singapore COVID-19 Temporary Measure Act offers temporary relief to businesses and individuals who are unable to fulfill their contractual obligations due to COVID-19 pandemic. So in Malaysia here, several measures have been announced by our government, such as increasing the winding up threshold from 10,000 to 50,000 and the time period of the statutory demand to 6 months, and also some extension of time for company to hold AGM, extension of time for company to file a statement of account, and so on. No doubt these measures are well intended and may help companies to survive. However, whether these announcements have the force of law remain questionable. I'm sure these announcements are made to protect and help the companies in Malaysia and businesses also. However, in this difficult time, uncertainty is really the last thing we need. I hope the Malaysia government would consider passing an act like Singapore to properly coordinate and implement these measures to contain the COVID-19 impact. So in the meantime, we can only make do with what we have at hand and continue to have faith with the professional in our construction industry to overcome this pandemic crisis. So speaking of professionals, are academic qualifications enough to be qualified as a professional nowadays in the construction industry, or you will require a professional qualification next to your name for you to be considered as a professional? As we know, professional qualification takes serious investment of time and money. So is it worthy to pursue this professional qualification or not? Tomorrow, we will have a discussion on this topic, and coming on board as our guests are, as you can see on the screen, Dr. Nasim, H.T. Ong, Nick Sunderland, and Dr. Ehsan. An interesting combination of guests, isn't it? So I'm sure you want to see them debating on this topic. Don't miss it. Okay. Lastly, I also want to announce that the L2 construction series is in collaboration with Lighthouse Club KL to run a campaign called Sharing is Caring. This campaign is for good cause and is aimed to help distressed individuals in the construction community during these hard times. All the contributions will be made directly to Lighthouse Club KL. And as I said, and I repeat again, the contributions will be used to help distressed individuals in the construction communities. So apart from the contractual and employment problem we have been discussing over the past weeks, there are many other real issues whereby people are struggling to put food on their table at this very moment. Let's show our kindness. Also do what we can for our beloved construction community. So on our part, we will help to promote this campaign and put all the sponsors' logo or name on display on our sessions till the end of MCO. So for more information, you can contact Lighthouse Club KL. Your support really matters. So thank you all. See you tomorrow and enjoy the rest of your day. Thank you, Spring. Thank you, Loon. Thank you, Yi Hong, and thank you, Zhen Yu. See you again.
Thank you all.
Thank you.
Thank you.
Thank you, everyone.
Stay healthy and stay